Welcome to Employment Law This Week. I'm George Whipple. EEOC's first disability discrimination lawsuit connected to the pandemic is here. Epstein, Becker, Green's Shira Blank joins us to talk about what implications the case might have for work-from-home accommodations in the future.
Even before the COVID-19 pandemic, one of the reasonable accommodation requests that employers had been increasingly getting were requests to work remotely. When offices throughout the U.S. closed at the start of the pandemic and forced employees to work remotely in order to stop the spread and to promote social distancing, it showed that a lot of work could be done effectively remotely. At that time, we predicted that in many instances, employers were going to have a tougher time showing that remote work was not a reasonable accommodation, or that certain employees are unable to perform the essential functions of their jobs through remote work, which undercuts one of the main defenses that employers would advance when denying such a request. Now, with vaccination rates increasing and the COVID rates decreasing in many cities, many employers have started instructing employees to return to in-person work, but employers still need to consider their obligations under the ADA. In Mountcree versus ISS Facility Services, the EEOC asserts that Mountcree worked remotely, along with all of the other employees, from March to June 2020, at the height of the pandemic. When the facility reopened and the employees were asked to return to work, Mountcree claims that she asked to work remotely 2 days per week because of a pulmonary condition, which she claimed increased her risk of contracting COVID. She claimed that other employees were allowed to continue working from home, but her request to do so was denied and she was fired. At this point, the Biden administration is in place, and what we're seeing is a significant focus on civil rights. They're aggressively advocating for the rights of people that they feel have been left behind in the COVID-19 pandemic and generally, and this logically extends to certain employee groups. What this shows us is that the EEOC is closely watching and is interested in litigating cases where an employer fails to provide employees with reasonable accommodations in connection with requests for remote work during the pandemic. As companies are now considering employee requests to continue working remotely on the basis of a disability, they need to make sure that they're actively engaging in the interactive process and also seriously considering whether that employee was able to effectively work remotely during the pandemic. They also need to consider whether that employee would be able to perform the essential functions of their jobs if they were permitted to continue working remotely as they likely had been previously. Companies also need to look at whether some employees are being permitted to telework and what distinctions they're making when they make those determinations so that they're consistently enforcing their policies.
Thanks, Shira, and thank you for watching. We'll see you next time.